Good morning, one and all. Legal research methodology and comparative analytical study between constitutionalism and constitution. Tools of studies: constitutionalism versus constitution all over the world, international countries abiding International Court of Justice. Modern political thought draws a distinction between constitutionalism and constitution. A country may have the constitution but not necessarily constitutionalism. For example, a country with a dictatorship where the dictator's word is law can be said to have a constitution but not constitutionalism. The underlying difference between the two concepts is that constitution ought not merely to confer powers on the various organs of the government, but also seek to restrain those powers. Constitutionalism recognizes the need for government but insists upon limitations being placed upon governmental powers. Constitutionalism envisages checks and balances and putting the powers of the legislature and the executive under some restraints and not making them uncontrolled and arbitrary. Unlimited powers jeopardize freedom of the people. As has been well said, power corrupts and absolute power corrupts absolutely. As has been well said, power corrupts and absolute power corrupts absolutely. If the constitution confers unrestrained power on either the legislature or the executive, it might lead to an authoritarian, oppressive government. Therefore, to preserve the basic freedoms of the individual and to maintain his dignity and personality, the constitution should be permeated with constitutionalism. It should have some inbuilt restrictions on the powers conferred by it on governmental organs. Constitutionalism connotes in essence limited government or a limitation on government. Constitutionalism is the antithesis of arbitrary powers. It was decided in Charles H. McIlvaine, Constitutionalism, Ancient and Modern, page number 21. Likewise, C.A.G. Smith, Constitutional and Administrative Law, 34, page 1977. Likewise, Giovanni Sartori, Constitutionalism, Bibliography, a Primary Decision, 1962, page 56. AMPOL SC REV, page 853. Once again, I remind it. Constitutionalism connotes in essence limited government or the limitation on the government. Constitutionalism is the antithesis of arbitrary powers. Constitutionalism recognizes the need for government with powers, but at the same time insists that limitations be placed on those powers. The antithesis of constitutionalism is despotism. Unlimited power may lead to an authoritarian, oppressive government which jeopardizes the freedoms of the people. Only when the constitution of a country seeks to decentralize power instead of concentrating it at one point and also imposes other restraints and limitations thereon. Does a country have not only constitution but also constitutionalism? Constitutions spring from a belief in limited government. It's stated in WHEARE, where OP citation 7. Constitutions spring from a belief in limited government. According to Squats, SCHWARTS, according to Squats, in the USA, the word constitution means a written organic instrument under which governmental powers are both conferred and circumscribed. Squats emphasizes that this stress upon grant and limitation of authority is fundamental. As Professor Weil has remarked in MCJ Weil Constitutionalism and the Separations of Powers, Volume 1, as Professor Weil has remarked, such as Western institutional theorists have concerned themselves with the problems of ensuring that the exercise of governmental power, which is essential to the realization of the values of their societies, should be controlled in order that it should not itself be destructive of the values it was intended to promote. The idea of constitutionalism is not new, it is embedded deeply in human thought. Many natural law philosophers have promoted this idea through their writings. Some of these philosophers are Aquinas, 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 Paine, Paine, Locke, 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 Grotius, Grotius, and Rousseau, Rousseau. As per Friedman legal theory, Dias and Hughes jurisprudence, Lloyd Introduction to Jurisprudence book. The Magna Carta 12 strengthened the traditional view that law is supreme. As observed by Arthur Sutherland, the Great Charter was obviously cherished standard, a welcome assurance that people could set some limitation on the arbitrary power of king. It's stated in Constitutionalism in America, page 13. A written constitution, independent judiciary with powers of judicial review, the doctrine of rule of law, and doctrine of separation of powers, free elections to legislature, accountable and transparent democratic government, fundamental rights of the people, federalism, decentralization of power are some of the principles and norms which promote constitutionalism in a country. Once again, I humbly submit in this legal research methodology paper. Tools of study is a comparative analytical study between um, constitution versus constitutionalism. For example, a country with a dictatorship where the dictator's word is law can be said to have a constitution but not constitutionalism. The underlying difference between the constitution versus constitutionalism is that a constitution ought not merely to confer powers on the various organs of the government but also seek restrain those powers. Constitutionalism recognizes the need for government but insists upon limitations being placed upon governmental powers. Constitutionalism envisages checks and balances and putting the powers of the legislature and the executive under some restraints and not making them uncontrolled and arbitrary. Likewise, proviso is constitutionalism recognizes the need for government with powers, but at the same time insists that limitations be placed on those powers. The antithesis of constitutionalism is despotism. Um, so, the International Court of Justice, uh, as per International Court of Justice, as per international law abiding, uh, all the countries, um, he is scientifically, dynamically doing evolutionary process of constitution framing. More than that, evolution of constitutionalism is enriching uh, justice all over the international judicial system of each and every one country's land law or grand norm or constitution or in the name of uh, supreme law. Each once again I come to the brief or come to the gist of the this legal research methodology tools of study of on constitution versus constitutionalism. A country may have the constitution but may not have the constitutionalism. So my hypothesis in this legal research methodology with these tools of study is every country should do evolutionary process of constitution framing and each and every country should frame their own land law or grand norm theory which is called as the constitution, but also each and every country should enrich, equip their own grand norm theory or their own land law, their own constitution towards the constitutionalism is my hypothesis. Rendering justice for aggrieved is the natural justice. It is the real truthful rule of law. Go ahead, rule your own arena as a juris aspirant. This is and thanks to all.